May it please the court.
You may proceed.
My name is Scott Woods again, and I'm agent for the Commonwealth of Revisia. I will primarily discuss the issues surrounding Revisia's lawfully classified intelligence and Mr. Ricardo Donati. Beginning with the intelligence issue, it consists of three core components. First, Revisia is not required to turn over its lawfully classified intelligence. Second, no evidentiary benefit can be given to Alicanto for this non-production. And third, this court cannot determine the actions of the Secretary General regarding this intelligence to be lawful. First, Revisia is not required to turn over this classified intelligence. The court lacks the power to compel the turnover of any information or intelligence. As Alicanto noted, Article 49 of the ICJ statute explicitly uses the language request from party states, and that any refusal may only be noted on the record. Further demonstrating this lack of compelling power, scholars have compared the ICJ statute to that of the International Criminal Tribunal for Yugoslavia. And in that case, the ICJ was noted as having a lesser power to compel than the Criminal Tribunal for Yugoslavia. In the Yugoslavia Tribunal, it required a Security Council resolution in order to compel the production of evidence. Thus, this court would have even more limited ability to compel the production.
Well, let me ask you this. What is, using that type of standard, what's to stop the country of, your country from overclassifying everything and titling everything as a classified document so that you don't have to release any of it? What's the safeguard in place?
I believe there is a general practice and principle of international law recognizing that states may protect state secrets and for the national security interest when disclosure would reasonably endanger the nation or the citizens of that nation in their duties or abroad.
But who's going to be the judge of that? Is it going to be someone from your country, or is it going to be the UN?
I believe there is currently no international law regarding that decision, and thus it would be the domestic laws of each individual country regarding classification. And in fact, I will discuss later that state secrecy privilege and the international law regarding the Secretary General's policy has not risen to international law. Regarding the state secrecy privilege in general, this court has recognized its existence in the Corfu Channel case in the 1950s, where the United Kingdom refused to produce documents based upon naval secrecy. The court recognized that and refused to require this production. Further, this court has noted recently, as Alicanto has noted in Bosnia for Serbia in 2007, that it need not even reach the state secrecy exception when there is other available evidence. Here there is other available evidence. We have the independent evaluations of NGOs stating that thousands of Alicantans are fleeing on fear of imminent genocide and imminent mass killings. We have the concession by Alicanto that killings have occurred at the behest and official capacity of its own agents. And we have the recognized burning of villages by other independent evaluators. Turning to the fact that Alicanto should not receive an evidentiary benefit for this non-production. In the Minkiers case, this court noted that it cannot make any legal conclusion based upon non-produced evidence. It may only make conclusions upon the evidence before it. While a legal inference may be given, he must have the opportunity for retrial in his presence in order for a country to be required.
But you cannot get both the benefit of you not showing up and by virtue of not showing up, getting a benefit out of that.
Your Honor, I believe it would be Ricardo Donati not showing up, and the fact that state practice has continually been he must be given a chance for retrial in his presence, whether or not he was given sufficient notice and he basically ignored that notice.
So are you saying that he did get the notice, or that
I am saying that we do not know whether he did receive such notice. There was widespread television and radio broadcast that there was a search for him. And
surely he was aware that there was a trial underway.
We do not know or do not argue whether or not he was or not, but even if he was aware...
But is he not under your control?
He is under our control, and even if he was aware that the trial was underway, I believe there other avenues of discretion exist. including that he must be given a trial in his presence. The note is, and he must be given a trial in his presence, not just that he be given a notice. The other avenues of discretion include the fact that the application of ex post facto laws would be Donati, as well as the fact that the law does not require it. Ex post facto application of the death penalty and the trial in absentia would again violate the International Convention on Civil and Political Rights, Article 15.1. The state of Alacanto has argued that this is of no matter and does not rise to a significant enough occurrence of a violation of human rights. This cannot be, as it explicitly took this obligation upon itself. It is not whether it has risen in customary international law to such a level, but whether or not the state of Alacanto has taken this obligation upon itself. It has. Thus, this violation is grounds for Revisia not turning over Mr. Ricardo Donati.
So you're arguing that the Alicante people themselves might be in further turmoil by turning this man over for Alicante to trial?
Yes. Yes, Your Honor.
I'm not sure I understand the logic behind that.
I would argue that it would further incense the ethnic groups, and that the fact that the government is controlled by, I believe, the Zimbabwe people, and the groups that are fleeing on threat of mass killings are the Dasu. Mr. Ricardo Donati was involved in the Dasu movement, and thus him being subject to what would be considered an improper trial or improper punishment would only further incite resistance to the government and further violence. Finally, there is one further avenue of discretion to exercise. States may refuse to extradite if there is imposition of the death penalty and it has not been adequately assured that the death penalty will not be imposed. This is recognized by a multitude of treaties, including the United States Treaty with Canada, the United States Treaty with Mexico.
So are you saying that it's a matter of customary international law?
I'm saying as a state, yes, customary international law, it recognizes that with the death penalty is to be imposed, a state may refuse without proper assurance that it will not be imposed. This is further evidenced, again, by the Model Treaty on Extradition adopted by the United Nations General Assembly, Article 4D, which states that, again, if the death penalty is to be imposed, the state may refuse without adequate assurance it will not be. I would also further like to distinguish the fact that it need not matter if Mr. Ricardo Donati is classified as a terrorist. In the Lockerbie case, there was a treaty, and it did require extradition or prosecution in the alternative. This has not arisen, the extradite or prosecution alternative has not risen to customary international law, as that case noted. That case further noted that it required a Security Council resolution upon Libya to force the turnover. Thus, this court is without power, absent a treaty, to force the turnover of Mr. Ricardo Donati. If any body of the United Nations withholds that power, it would merely be the Security Council. Returning for a moment to the evidentiary issue, I would also like to note that Alacanto has relied upon the state secrecy privilege as well. In the prosecution and investigation of Mr. Ricardo Donati, it refused to relinquish records of this investigation based upon the national security grounds. Thus, between these two countries, there exists a principle of international law common to both of them, and thus should be recognized amongst both of them, whether or not it is customary international law. In conclusion, I would like to state that Mr. Ricardo Donati need not be turned over to Alacanto, and the evidentiary issue should be ruled in favor of Revisia, that it need not produce its lawfully classified intelligence, and it would be unlawful for the Secretary General to turn it over.